Hello, everyone. Thank you for joining me and Secrest Wardle for the Michigan PIP Monthly March 2018 edition. My name is Javon David, and I am a partner at Secrest Wardle's Troy location. We do this monthly podcast and webinar to provide you with an on-the-go opportunity to stay on top of the law and hear about some trending topics that are percolating in first-party practice. Certainly, these are common issues that we see on the defense side that would likely be relevant to you as a claims adjuster or manager or supervisor, or even an in-house attorney that is facing these similar issues that we see on a day-to-day basis. For the March 2018 podcast, we are going to go through some of the recent Court of Appeals decisions and also talk about a trending topic of Reptile Theory, which is a tactic that plaintiffs can use in deposing you in first-party actions. But actually, the theory extends from the very beginning of a case and all the way through trial. The Reptile Theory is one that was created by a very prominent litigator that has now kind of transformed the way that a lot of litigation is being conducted, especially in bad faith claim handling, but also we see it seeping through into first party practice as well. Now, for the Court of Appeals update, which we'll go through first, this is simply an overview of the cases that have come down from the Court of Appeals since the last podcast. So from late February through the entire month of March, it's cases that you should be aware of in your general claim handling so that you can think more critically about the claims process and, recall these cases so that you can use them as a guide in making decisions on the day-to-day adjustment of your claims. Now, there were 4 cases that are worth truly discussing and going through in the Court of Appeals for March of 2018. There was the Cornelius versus MACP case, which stands for the proposition that a motor vehicle must actively contribute to a motor vehicle accident in order for an individual to obtain first-party benefits. There's also the Tipout versus Farm Bureau case, which involved a fraudulent claim for transportation services. We'll get into the facts and specifics of that, but ultimately the court ruled that utilizing transportation services while physically able to drive is fraud. The parties battled that in the trial court and all the way to the Court of Appeals, but ultimately the defendant prevailed. There's also the Yousef versus State Farm case, which involved the social media of the claimant to reveal the fraud in the 8-hour-a-day attendant care claim. And lastly, there is the Bowdoin versus MPCGA case involving attorney fees from an accident that is nearly 20 years old. Ultimately, the court ruled that there's no attorney fees warranted without proof of unreasonable delay in payment. And we'll go through the pertinent points of each of these cases so that you can think about how they apply to any current claims that you have or will have in the future. The Cornelius versus MACP case, which came out of the Court of Appeals in late February, involved the MACP and the trial court ultimately denying the MACP's motion for summary disposition, finding that MCL 500-3113 and 3101 did not bar the plaintiff's claim for PIP benefits where 2 collisions constituted separate accidents. In the Cornelius case, the plaintiff was operating his Ford Expedition in Detroit. As he approached the intersection, he became tired, closed his eyes suddenly, and ultimately rear-ended an Envoy that was stopped at the intersection. Neither vehicle left the lane from the impact. After the collision, the plaintiff and the driver of the Envoy exited their vehicles and began walking toward the sidewalk. As the plaintiff entered the westbound lane on Davison, which is a street in Detroit, he was struck by a black Charger that was driving in that lane. The driver of the Envoy testified that between 30 seconds and 1 minute passed between the 2 collisions. Significantly, the plaintiff's insurance policy on the Expedition lapsed at the time of the accident because he failed to pay his policy premiums. After the plaintiff was released from the hospital, he applied for benefits with the MACP pursuant to MCL 500-3172, which is the statute that provides that an injured party may obtain PIP benefits from the assigned claims plan if no PIP insurance applicable to the injury can be identified. After the MACP refused to assign an insurer, the plaintiff filed the lawsuit. The MACP then moved for summary disposition, arguing that the plaintiff was excluded from collecting PIP benefits since he was injured in an accident that involved his own uninsured motor vehicle. The trial court denied the defendant's motion, finding that the plaintiff's vehicle was not involved in the second accident in which he was struck by a pedestrian for purposes of the No Fault Act. The defendant then appealed the decision, and the Court of Appeals noted that MCL 500-3101 requires the owner of a vehicle register his vehicle and obtain insurance in order to have a viable claim for first-party benefits. Again, an injured individual is not entitled to PIP benefits if at the time of the accident, the individual was the owner or registrant of a motor vehicle involved in the accident with respect to which the security required was not in effect. That's a long-winded way of saying that the person failed to secure no-fault insurance on their motor vehicle and then was subsequently involved in an accident and then seeks first-party benefits. As we all know, Michigan law does not allow you to obtain benefits if you failed to secure your vehicle with the proper insurance. In the Cornelius case, there was truly no question about whether or not the plaintiff was operating an uninsured vehicle. He admitted that he did not have insurance on his vehicle. The only true question for the Court of Appeals was whether the plaintiff's uninsured vehicle was involved in the collision with the black Charger, thus precluding him from obtaining first-party benefits. The Court of Appeals looked to a seminal case of Michigan Mutual Insurance Company versus Farm Bureau, which states that for a motor vehicle to be considered involved in the accident under MCL 500-3113, there must be some activity of the motor vehicle that actively, as opposed to passively, contributes to the happening of the motor vehicle accident. In the case involving Cornelius, the physical proximity of the vehicle to the accident was not sufficient evidence to conclude that the vehicle was involved in the accident. The court ultimately concluded that the plaintiff's expedition did not actively contribute to the injuries plaintiff sustained after he was struck by the black Charger when trying to leave the scene of his first accident. So while the expedition and the envoy actively contributed to the first collision, only the black Charger actively contributed to the second collision when it made contact with the plaintiff when he was crossing the street. The court found it significant that plaintiff's expedition had no influence on the black Charger whatsoever. Therefore, the court reasoned that because plaintiff's expedition did not influence the operation of the black Charger, the plaintiff's expedition that was uninsured did not actively contribute to the second accident. Ultimately, the court ruled that plaintiff was entitled to first-party benefits and that the trial court did not err in finding that the collisions were separate accidents that did not bar the claim for PIP benefits. The court therefore affirmed the trial court's denial of defendant's motion for summary disposition. This case is significant in assessing when there are multiple motor vehicles in an accident. The courts went through a description of how you have to look at each separate vehicle and how that vehicle was involved in the accident to determine whether or not a person was in fact injured or utilizing an uninsured motor vehicle in the accident. Here, the court determined that the uninsured motor vehicle, although was involved in the first accident just a few minutes prior, the uninsured vehicle was not involved in the second accident in which the claimant was struck by a motor vehicle. Now, moving on to the second case that came out from the Court of Appeals, ironically on the same day of the prior case. The Court of Appeals was pretty busy on the 27th of February. But this was a case of Tipout versus Farm Bureau. And in that case, the plaintiff was involved in a motor vehicle accident that he claimed rendered him disabled from doing a host of things, including performing household services and driving himself. Plaintiff visited his primary care physician, who authored a disability certificate disabling him from driving and indicating that he required transportation services for the month of March of 2014. In support of the claim, plaintiff submitted a signed and initialed travelogue for March 7th and March 10th of 2014 and sought reimbursement for the transportation to and from his treating physicians. Importantly, the log that plaintiff signed specifically stated, quote, "By signing in the space below, I verify and agree I have received transportation to and from the facility located at the above and below addresses based on my doctor's authorization due to my physical limitation of driving, unquote. So the plaintiff specifically signed a document stating that he required transportation services due to his physical limitation of driving. The attorneys obviously attached that to the motion for summary disposition, arguing that this was fraud. But what was more compelling and clearly carried the day with the appellate court and the judges was that Farm Bureau hired a private investigator to surveil the plaintiff. It was undisputed that on March 7, 2014, the investigators videotaped plaintiff utilizing the transportation company's services. On that same exact day, the plaintiff was also observed driving himself to a gas station, a bank, and a banquet hall before ultimately returning home. The investigators recorded similar activities the following day, again, another date in which the plaintiff received transportation services to his medical appointments. And quite frankly, we see this all the time where, this person is admitting to driving on their own, but they're still utilizing transportation services. Oftentimes, the response at the deposition as to why they're able to drive to, the grocery store versus the medical appointment is that, the grocery store is closer to my house, or I can only drive short distances, I can't drive long distances. In those situations, it's imperative for your defense counsel to ask questions about how far, certain locations are, and then subsequently compare those locations to the location of the medical facility to the plaintiff's home. That certainly would be compelling in a case evaluation summary, facilitation summary, or even arguably in a dispositive motion in conjunction with the more concrete evidence like the forms themselves and the surveillance. Now, in Tipout, the Court of Appeals went through the whole fraud argument and stated that a plaintiff's insurance policy that contains a fraud provision necessarily binds them to the language of that provision. Here, the Farm Bureau policy did contain an intentional concealment or misrepresentation clause that stated, in the event that an insured intentionally concealed or misrepresented material facts or circumstances, then they are precluded from collecting on the loss. On appeal, the plaintiff argued that he never made a misrepresentation because transportation for medical treatment is an allowable expense under the No-Fault Act, and that because he legitimately required medical treatment, there was no fraud in receiving payment for transportation to that treatment. The Court of Appeals disagreed, relying upon the standards set forth in Bahri versus IDS for upholding granting of summary disposition based upon a fraud exclusion policy. The court explained that plaintiff's verification on the travel log incorporated by reference in plaintiff's doctor's certification and documents demonstrated his complete inability to drive, or at least his claim that he was completely unable to drive. Therefore, it was admissible against the plaintiff under the Michigan Rules of Evidence. As a result of the log entries, the claim was submitted to Farm Bureau seeking payment for transportation services on days where the plaintiff was clearly able to transport himself. Plaintiff then attempted to argue that the misrepresentation was not material because there was no evidence that plaintiff had made any false statement beyond the submission of a fraudulent travel log. However, the court noted that on the basis of Bahri alone, plaintiff's false submission seeking payment for transportation services was itself a material misrepresentation as a matter of law. Based upon the plaintiff's submissions of travel logs, there could be no question that Farm Bureau successfully established plaintiff committed acts encompassed by the fraud exclusion provision of the insurance policy. Accordingly, the trial court did not err when it granted summary disposition in favor of Farm Bureau. Now, the next case of Yousef versus State Farm is also one involving fraud. That one involves the social media aspect and the plaintiff's misrepresentations that specifically contradicted what he was posting on social media. In Yousef versus State Farm, the plaintiff, Mario Yousef, as an ex-friend, as he was a minor, filed a suit for first-party benefits following a May 2014 motor vehicle accident. He claimed to have very serious injuries, including injuries to his head, his neck, and his lower back. He submitted a claim for PIP benefits to the placement facility and was assigned to State Farm through the Michigan Assigned Claims Plan. The plaintiff claimed to be bedridden following the motor vehicle accident. He claims that he rated his pain on a daily basis of 9 to 10 on a 1 to 10 scale. He also testified that he needed significant household services and attendant care on a daily basis, totaling up to 8 hours of attendant care per day. Plaintiff's Facebook post portrayed a very different picture as to what was truly going on with him following the motor vehicle accident. The plaintiff was posting photographs of him completing his high school education, posting pictures from graduation, more photographs of him at his graduation with his friend. And what was even more apparent as to the fraud was his out-of-state travels. The plaintiff posted pictures of him driving to Tennessee and hiking across the Smoky Mountains. And he also traveled to Las Vegas sometime before his deposition. So he goes to Vegas, he travels, he's able to get on a plane, and then soon after is testifying and claims that he requires extensive household services, that he was bedridden for a year after the accident, and that he continued to need 8 hours a day of attendant care due to a head injury and orthopedic injuries. Defendant moved for summary disposition, arguing that plaintiff fraudulently misrepresented his capabilities in effort to sustain his claim. As this was an MACP carrier, State Farm didn't have the ability to rely upon the usual policy language that is used in a Bahri motion like this, but instead notes that 3173 provides that a person who represents or causes to be presented an oral or written statement, knowing that the statement contains false information concerning a material fact to the claim, commits a fraudulent insurance act under 4503 that is subject to penalty. The penalty is that the person becomes ineligible for payment of first-party benefits from the assigned claims plan. Now, this is an important side note that often when you're representing an assigned claims carrier or you are the assigned claims insurer, the plaintiff attorneys will argue with you about whether or not you can bring a Bahri motion. And they'll say that Bahri was based on the policy language of the insured's policy. And here you don't have the luxury of having that policy language. Therefore, you can't deny the claim based on fraud. I've seen it argued that way. It always baffles me as to why a plaintiff attorney would think that's even a viable claim, especially given the specific language in the statute that allows the claim representative or the claim to be denied based upon fraudulent misconduct and fraudulent material representations. So, always know that if you are the assigned claims carrier, you still have the ability to adjust a claim for fraud under case law at the common law level, but also it's written directly in the statute for you to use. Now, here, the State Farm assigned claims carrier moved for summary disposition, argued to the court that the Facebook posts were a party admission and showed that plaintiff was traveling to Vegas days before his deposition, he graduated high school, and he visited with friends. All of this was contrary to his testimony that he was essentially bedridden after the accident and continued to require 8 hours of attendant care. The court found in favor of defendant and dismissed the claimant's lawsuit. Now, for the last case from the Michigan Court of Appeals is the Bowdoin versus Michigan Property and Casualty Guarantee Association, which arises out of a very old accident, 20-year-old accident. And in that case, the plaintiff sustained very serious injuries and had brought in a repeat lawsuit for ongoing medical expenses for injuries sustained in the motor vehicle accident. Immediately upon receiving the lawsuit, the plaintiff attorney requests a claim for attorney fees and requests an evidentiary hearing with the court regarding the attorney fees. The plaintiff argued that defendant did not immediately pay the claim as it relates to the plaintiff's allegations of neck pain resulting in the subject lawsuit. The trial court determined that plaintiff failed to present reasonable proof of loss and that as a result, the defendant did not unreasonably delay in paying the first-party benefits. When making the arguments for attorney fees, the plaintiff attorney argued that a 2008 IME report from Dr. Javon indicated that the claimant's neck pain was likely related to the accident. The plaintiff also claimed that defendant was on a reasonable notice that her neck pain was related to the accident due to the fact that the claim file produced in August 2014 noted that she had been experiencing neck pain for a year since the motor vehicle accident. Ultimately, the trial court agreed with defendant that it did not obtain reasonable proof of loss until it received the IME report of Dr. Matlin on February 5, 2016. Plaintiff appealed the opinion and order with the primary issue of whether or not the plaintiff submitted sufficient proof that her treatment for neck pain was related to the accident, and whether, as a result, the court should have approved no-fault insurance payments for treatment upon submission of the bills, in addition to interest and attorney fees. The Court of Appeals looked to the statute 3148, which states that attorney fees are charged against the insurer if the court finds that the insurer unreasonably refused to pay the claim or unreasonably delayed in making prompt payment. In support of the position that the lower court erred in ruling against her, the plaintiff relied upon the 2008 IME report of Dr. Javon, a 2014 notation within the claim file, and again, her assertion that she had been presenting claims for neck pain to the carrier since 2014. The Court of Appeals disagreed with the plaintiff and agreed with the trial court. The court found that it is not reasonable to expect the defendant insurance carrier would have taken plaintiff's word for the explanation of her neck pain, and that the claims adjuster reasonably interpreted plaintiff's statement regarding her neck pain as a claim and not as proof of loss. Now, that is significant. She presented the claim for neck pain, but that does not mean that she presented proof of loss. Oftentimes, plaintiff attorneys will conflate those two. The court also stated that to the extent the plaintiff attempted to argue that the bills submitted by treating providers were proof of loss, the court determined that this is not tenable. The bills, like plaintiff's statement, were part of the claim for the loss, but did not reasonably establish a link between the accident and the neck issues. Ultimately, the court found that the trial court did not err in concluding that defendant did not receive reasonable proof of loss until it received the IME report of Dr. Matlin in 2016. Now, moving on to a topic that has gained more popularity in recent times, but truly in the last handful of years or so, is this whole reptile theory discussion. And so today we'll talk about adjuster depositions and preparing for questions rooted in the reptile theory. Probably many of you have heard of the reptile theory, but I'll just briefly go over what exactly it entails and how plaintiffs are using it to seep into these first-party cases, especially at adjuster depositions. Now, the reptile theory is attributed to two individuals, David Ball and Don Keenan, who co-authored the book Reptile, the 2009 Manual of the Plaintiff's Resolution. This was a book published in 2009 that discussed tactics to attacking, at that time was primarily bad faith claims in insurance claims adjusting in a broad array of different types of claims. Now, what we are noticing is that this theory is no longer just used in products liability cases or bad faith claims across the country. Insured and attorneys are increasingly seeing this in first-party cases. As a result, witnesses for the insurance companies need to be prepared in how to respond to these tactics, especially at depositions and at trial. Now, the goal of reptile theory is to structure a case in a way that causes jurors to switch their brain into survival mode when they're deciding a case. So, when you have a trial, you present the evidence to the jury, you remind the jury repeatedly to only rule on the evidence before them, not to rule based on their emotion or how they feel about any of the parties personally. It's strictly a verdict based on the evidence in its entirety. And the goal of the reptile theory is to change that and to make it so that a juror's brain switches into what's called survival mode when they are deciding a case. So rather than deciding the case on logic and admissible evidence, the plaintiff attorneys want the jury to place themselves in the position of the insured and feel threatened regarding a potential risk of harm. They want to invoke the sympathy and the fear of the juror and ultimately cause the jurors to ask themselves, well, what if this claim denial happened to me? What if I had a surgery and it wasn't paid for by my carrier and then I was stuck with the bill? What if I needed attendant care and my spouse took time off work to care for me, but now the insurance carrier is not paying them? That is what they are being triggered into focusing on the insurers is, what if this was me? Rather than focusing on whether the plaintiff was actually harmed by the defendant, whether there was reasonable proof, whether the services were necessary, or whether the surgery was necessary. again, in first-party PIP cases, the successful use of the reptile theory involves the plaintiff attorney not arguing about whether or not the insurer properly denied the claim, whether or not the surgery was necessary, whether or not the person actually sustained injuries in the accident, but instead arguing about what could happen to the jurors if their insurance claim was denied or if their surgery bill was not denied. So we've seen, this happened a lot initially on the East Coast and in cases primarily involving products liability. A lot of cases in the South have actual penalties and lawsuits for bad faith claim handling. That's not really the case in Michigan. But what we're finding is that attorneys are able to still accomplish this quote-unquote reptile theory by asking questions to the adjuster in first-party cases that appear to be rooted in this, jurors want to feel safe and you are not causing them to feel safe based on your claim handling. And therefore you are handling claims in a way that's dangerous to the community, and you're handling claims in a way that's dangerous to an everyday person, and that everyday person could ultimately be a juror on the next claim. And that is how they get into, the minds of the jurors and cause them to act based on instinct rather than logic. So, we've gone over briefly what reptile theory is. If you have more questions about it, feel free to give me a call or reach out to me or one of my colleagues on the issue. But how is this accomplished? How do the plaintiff attorneys accomplish this reptile theory before we even get to trial? And they primarily do that. Their big shining moment is when they take the deposition of the adjuster. And they ask questions to the adjuster that are posed in a way to make the adjuster appear disingenuous or as though they are handling a claim with some sort of additional intent. And the plaintiff attorney will often try to show the jury or show the judge that the adjuster violated some applicable social rule. So, for example, in the deposition of an insurance adjuster in which the plaintiff attorney is going to use the reptile theory to prosecute the case, the attorney will present a series of questions regarding what they will attempt to describe as quote-unquote plain and simple rules. And they'll make questions regarding these rules appear to be difficult or impossible for the adjuster to disagree with. And so they'll get the adjuster to acknowledge that the purpose of the rule is to protect insureds from improper denials. So, for example, just some examples of some questions that we've seen and that we've, flagged as important to be mindful of is questions such as this. The plaintiff attorney will say something like, you would agree that adjusters should act with integrity when investigating a claim for PIP benefits, right? If that's asked to you at a deposition, you might instinctively think to say, yes, of course I'm going to act with integrity when investigating a claim. Now then they'll say, do you think that you were acting with integrity by not telling my client that they were suspected of intentional misrepresentations in the application for benefits? Obviously that causes you to take a pause there, doesn't it? Now the answer might be, I guess not, or maybe I did, maybe I didn't. But they've essentially created the first rule of the umbrella questioning by getting you to agree that adjusters should act with integrity. Then they narrow that issue even more by saying, do you think that you were acting with integrity in this particular case? But they won't just say it so simply. They'll say by not telling them that they were suspected of fraud, by not telling them that they were having, SIU investigate their claim. Do you think you were acting with integrity when you did that? It would be a whole line of questioning with that point. Now, another example would be the plaintiff attorney can ask you, do you agree that an insurance company owes a duty to fairly adjust a claim? And the question seems very obvious. Yes, of course we have a duty to fairly adjust a claim. You're not going to testify that you unfairly adjust claims. But answering, no takes you down one negative path, but answering yes also takes you down a negative path. See, if you say, you agree that the insurance company owes a duty to fairly adjust a claim. Yes, I do. And you would also agree that the insurance company is required to promptly and fairly investigate a claim. Yes. Would you also agree that taking 7 months to deny a first-party claim was not prompt or fair? Then you pause, correct? That is how the reptile theory would play out in a deposition. It's by taking these general principles, these general statements, and getting you to agree with them, and then ultimately narrowing it down to how your particular claim handling in this particular case is contrary to what you just said. Now, how is this going to cause trouble down the line? Because this line of questioning allows the plaintiff attorney to obtain key admissions in support of an unreasonable delay in claim handling or claim processing. If the adjuster that is being deposed answers these questions just saying yes or no, both outcomes are negative. So if the adjuster fails to explain the actions, which could have been that he did act with integrity, because at the time of, for example, an EUO, there were suspicions, none of that would come out in the questioning. Because if you answer the question just saying yes or no, you're going to find yourself in a tricky position that's going to catapult you into more lines of negative questioning. Saying yes or saying no to integrity questions and questions that I just gave as an example of above leaves out key information that you can use in your testimony. So, going back to the question of, would you agree that taking 7 months to deny the first party claim for fraud was an unreasonable delay in claim handling? Instead of saying, oh, well, I guess not, or just say, well, no, because of X, Y, and Z. It could have taken 7 months due to delays by the plaintiff or the claimant in submitting documentation or submitting to an examination under oath. Always remember why the claim was denied in the first place and bring it up. If you denied a claim, there's a great chance that you had a valid reason for denying the claim, and so say that every opportunity that you can. Don't just provide them with these sound bites that they're going to utilize at trial or that they can quickly file a motion on the second your deposition is over. So, if the plaintiff attorney is successful in taking these reptile theory type questions, they're going to garner a lot of key admissions from your deposition. And then if you are testifying at trial, your transcript is going to be held in their hand, and they're going to say that you previously admitted X in your deposition. Why are you saying this now? Why have you changed your method of testifying or the answers to your questions now that we are at trial? And more likely than not, the judge is going to rule that they can cross-examine you with your prior testimony under these kinds of circumstances. So to counter this technique, it's critical for defense counsel, especially once you're gearing toward the adjuster deposition in litigation and at trial, to prepare the witness for the deposition. And arguably, it's easier said than done, in large part because the questions asked by plaintiff attorneys appear to be very common sense principles that a witness would not want to dispute. Of course, you don't want to dispute the fact that adjusters should act with integrity when claims handling. Of course, you don't want to dispute that an insurance company owes a duty to fairly adjust a claim. Those are not things that you're going to dispute in your deposition. But merely answering yes to those kinds of questions will lead you down a very sticky path, and you might not be able to recover if they've gone too far. So just be mindful that those are the kinds of questions that you'll see. The way to combat them is by saying, either I don't know what you mean by that, or while I adjust claims on a case-by-case basis, I can't speak to blanket ways of claims handling. That's not how we're trained. We're trained to look at all the facts. We're trained to look at all the evidence and all the documentation in making our decisions in claims handling. So for me to answer that question is not possible because you're asking for me to make a blanket statement about what is typical in claim handling, and I can't do that. Now, preparing for reptile theory questions, of course, first requires you sitting down with your defense counsel prior to the deposition and being prepared for these kinds of things. Oftentimes, these questions are overlooked because they're so general and they're so vague, and oftentimes they're not even really used by plaintiff attorneys because it takes a very skilled plaintiff attorney to execute this well. So first, defense counsel must first explain the reptile theory to the adjuster. Have them explain, sitting down, what is reptile theory? How is it seen? Is this a plaintiff attorney that typically utilizes this? Or where is this deposition testimony going to go? And responding to the reptilian questioning is a technique that requires the adjuster to avoid using instinctive responses to agree with abstract rules and common sense principles. So your attorney should explain to you that questions are unfair, they're vague, they're broad, and they fail to include the specific facts and circumstances of the claim at issue. And it's your job to point that out when these questions are thrown at you. Your attorney can, of course, object to the form of the question, and maybe that'll even alert you to the fact that something's not quite right about that question. But you, as the adjuster, need to, put your claim handling hat on and think, how does this question relate to my claim? And if I can't make that connection, then I need more clarification from the plaintiff attorney. I need the plaintiff attorney to explain to me how this relates to this claim. Are they asking for a blanket statement? Are they asking about my personal claim handling? Are they asking for this particular claim? And that will break down their reptile approach in getting you to unequivocally answer certain questions about instinctive and common sense principles about the integrity of claim handling or duties owed by claims adjusters. Now, of course, conducting mock depositions questions are imperative, and having kind of question and answer type questions to teach the adjuster to avoid agreeing with broad stated principles, and that simply yes or no will not be the appropriate response to those kinds of questions. The adjuster's response should include any practical concerns or exceptions that are present in the case, because we know not every case is black and white, and in particularly with insurance claims, each claim is investigated based on the facts and circumstances of each separate claim. So appropriate responses to questions about reptile theory is that we don't have these hard and fast rules that you're looking for. You can say things like, well, that question is really broad, or we don't have rules like that, or it just depends on the claim kind of thing. Or you can say, yes, but that has nothing to do with this case. Other responses could be, that's possible, yes, or I generally agree with that statement, but that has nothing to do with this case. And the adjuster needs to be prepared to further explain to the plaintiff attorney why it depends is their answer. And then the answer to that is because it has nothing to do with this case, because you're not asking me questions that are fact specific to this case. You're not presenting me with any documents. You're not presenting me with anything from my claim file that you have to get me to answer this question. You're just talking in general terms, and I can't answer that. So instead of simply agreeing that an insurance company is required to promptly and fairly investigate the claim, the adjuster can answer yes, but whether an investigation is prompt and fair depends on the circumstances of each claim. The same goes to the duty owed question. Is there a duty to promptly handle the claim? Yes, but whether something is prompt depends on the documents that we have at the time and whether or not I am even able to process that claim with what I have at that time. So these are practical tips for combating reptile theory in first-party depositions. Your counsel will go through these with you even more depending on the facts of your case. But at the end of the day, as we all know with deposition preparation, is that preparation is key. You have to know your claim, you have to know your log notes, and you have to know your claim file materials. Take time before the deposition, a week, 2 weeks before, to meet with your counsel and go through all of those materials. Meet with them a second time before the deposition, not an hour before, not the day of, even the day before. Make the time to go through your claim file and practice this key questioning that can ultimately cause you to look at, a riskier kind of testimony that could be used against you at trial. That is all that we've got for you this month. We provided some updates in the case law and some information about the reptile theory. But if you want more information, feel free to contact me or any of my colleagues. Again, my name is Javon David. I am a partner at Secrest Wardle in the Troy location. My contact information is located on the slides. But for those of you who are listening from your cars or on the go, my contact number is 248-539-2858. And again, Javon David, feel free to look us up on our website. Thanks for listening, and we will see you next month for Michigan PIP Monthly.